Look at the southbound lane of Constant Spring Road heading into halfway tree. We can see the congestion heading all the way up. And that is, we're reliably informed, heading all the way up into the Manor Park area. But it is moving. And so I trust that you're going to get where you are going today. Just take your time. Don't rush it. Don't rush it. Take your time. If you're late, you're done late already.
We're asking the taxi operators as well to respect the laws of the road.
Absolutely.
And all motorists, really, to respect the laws of the road. All right, guys, so welcome back to Sunrise. It's now time for Law and Order JA. Yep. And this morning, we're going to landlord and tenant, right? We're going to rent board, right? A lot of people would be familiar with that. Now, today, the dilemma that was sent in reads as follows. Jordan, a recent high school graduate, is about to start college and just signed a rental agreement for a small apartment near the campus. Upon moving in, Jordan finds out that the apartment is in poor condition. Despite several attempts to contact the landlord for repairs, Jordan has received no response. What legal steps can Jordan take to address these issues? Here with us this morning is attorney at law and partner at Duncox, Paulette Neal, and she'll be helping us navigate this one. Welcome, Miss Neal. Counsel, good morning. How are you?
Good morning.
Good morning. I'm fine, thanks.
Very well. Talk to Jordan, please, because a lot of people face this problem quite often.
Sure. So, firstly, the relationship between a landlord and a tenant in this particular scenario is governed by the terms that are agreed between the parties. Now, Jordan would have signed a written agreement, right? So the express terms of that agreement is necessary to be examined to determine what are the obligations set out in that agreement. In addition to the written agreements, there are certain obligations that are implied by law in a landlord and tenant relationship.
Right. So it's because I was about to ask that, say a rent agreement has a clause that he didn't read, which says, I don't have to fix anything until so and so and so. Can there be elements in an agreement that breach law, so they are null and void? They are in the agreement, but they're not enforceable?
Correct. Right. So there are certain terms that are implied, in law, right? So in this particular scenario...
So if it's not there...
Right. Even if it is not set out in the contract, there are implied terms.
Okay.
So in this scenario, it doesn't indicate whether Jordan lets the premises furnished or not, right? And the law actually implies a certain covenant if a premises is let furnished, that it is fit for human habitation. So when Jordan got possession of the premises, he examined it and realized that there were leaking pipes. We don't know the extent of these leaking pipes. Suppose it caused flooding, right, or other damage. There were broken windows. We don't know if, for example, as a result of the broken windows, it allows certain material to have access to the property. It could be infested with bugs. We don't know, right? The scenario also says that
mold
there
in
was
the bathroom.
mold in the bathroom.
To what extent?
And that is something that could cause some sort of serious health
issues,
right? So right away, in examining these scenarios cumulatively, the mold situation, the pipes that needs to be repaired and all of that could make the premises not deemed fit for human habitation.
So can Jordan then, but he's trying to reach the landlord and not getting through, what's his next step, or what is the remedy available to him in that regard?
Right. So if it is that the landlord breached that implied covenant in the situation where the premises was let furnished, and he breached that implied covenant for it to be fit for human habitation, then Jordan would be entitled to rescind the contract, right? He has that automatic right. Or even if, for example, the landlord had misrepresented the state of the premises, because we don't know if Jordan went and examined the premises initially. But even if he didn't, suppose he got photos of the property and the landlord gave the impression that the premises was in good state of repair. So if it is that the landlord misrepresented, then he could treat the contract as void.
But then, all right, follow me. What does that mean in real terms? Does that mean you can just leave?
It means he could terminate the contract the tenant could terminate the contract on that basis.
And get back his money.
Yes.
That is what I want to do.
Yes.
Because,
Yeah, you can get back your money.
Is it a case of, okay, I've paid you my rent,
right,
and I've paid you my deposit. Of course,
right,
you're going to give me back my deposit.
Right.
But I incurred costs to come and move my things in here, and then now I realize that the place stay bad. Mm-hmm. Is it that the landlord, well, you can leave? And
no,
that's the end of it?
Your money.
Well, if it is not habitable, if it is not fit, then, and it breach a term of the contract, then yes, he would be entitled to recoup that.
Well, let me just put this in counsel.
Both monies?
Both.
Yes,
okay.
the deposit and the
rent.
And this is probably for another show, because deposits really and truly are not legal. They're not supposed to take deposits from you, really. But it's for another show, right?
Okay.
But counsel, let me just ask you, if, say, for example, he can't find the landlord disappears, so he can't get the deposit back, he can't get the money, the rent back. What can he do? Does he go to the police station? Because that's not a criminal matter, but I'm just asking. Police station, or does he file a suit? What does he do? What can he do?
Well, the landlord must be somewhere. Certainly, he would have leased the premises from the landlord. Right?
Stop paying. Better if you stop paying rent, you find the landlord. The landlord will appear.
So if the tenant had terminated the lease and vacated the property, to recoup that sum, he would definitely have to find some means to find the landlord.
Okay. Now, people can be very unscrupulous, you know what I mean? And, you know, they just hightail off and they go on about their business. The number that you're calling, you call from now till, you know, from sunrise till sunset, and nobody's answering. So, you know, but what would you advise, though, counseling, just in terms of persons when they're letting premises, what are some of the things about which they ought to be mindful?
Okay, so firstly, it is important that you inspect the premises which you intend to lease, right? So examine the state of repair. You know, it would be important to ensure that you have a written agreement, and that the agreement sets out that the premises is fit for the purpose for which it is intended, right? So you have to ensure that, you know, examine, get a properly drafted agreement to ensure that the terms and the obligations for each parties are clearly set out in that contract.
If you have you're on campus, if you have a lawyer friend, even just for us, when you're a law student friend, read this over for me, please, because I don't know. Because so many times you don't know. So many times somebody has inserted a clause that you don't know. This is not standard in a rent agreement.
Yeah, and
what is this?
That might be detrimental to you in the long run.
Exactly.
Right.
So you have to read it and so on.
You have to know what you're reading.
Yeah.
You know, not everybody bright in everything. So get somebody who bright. Like how Paulette Neal bright till she turned partner at Duncombe. Get somebody who bright in that. Of course, our guest has been Paulette Neal, partner at Duncock's Attorneys on Duke Street. Shout out to our Sunriser for submitting that one. And to remember, keep those legal questions coming by sending them to our socials at CVM_television or at Sunrise CVM. Time's winding down here on Sunrise, but we're not done just yet. So stay with us now. We'll be right back.